Imagine a massive police sting, sirens, mugshots plastered across the evening news, a terrifying operation name like Fright Night, just completely dominating the local headlines.
Yeah, the whole community is buzzing.
Exactly. The authorities are giving these big press conferences, and it feels like this massive, undeniable victory for public safety. But then, imagine just complete silence.
Right. For 9 whole months.
Yeah, for 9 months. And it makes you wonder, where do those suspects go when the news cameras pack up and the public just, moves on to the next big story?
It creates this really profound illusion of a clean, structured narrative. I mean, we're so conditioned by television procedurals to expect, like, the inciting incident, the dramatic arrest, and then the swift gavel bang of justice.
All neatly packaged into a 45-minute window, right?
Exactly. But the reality of the criminal justice system is that the high-profile arrest is, well, it's barely the prologue.
Yeah.
Once the initial spectacle fades, the actual machinery of the system kicks in. And that machinery operates entirely out of the public eye.
Totally in the dark.
Right. It's slow, it's highly bureaucratic, and frankly, it's completely opaque to anyone who doesn't know exactly where to look.
Which brings us to you, our listener. Welcome to this custom-tailored deep dive.
Yeah.
You brought us a fascinating stack of documents, articles, and personal notes detailing this really intense local law enforcement sting.
Yeah. This was a major operation.
It really was. This operation went down in Morgan County, Alabama, back in October of 2025. And it was a highly coordinated effort targeting online child solicitation and human trafficking.
Right.
So today is July 18th, 2026. Almost 9 months have passed since those initial mugshots hit the internet. And you, the listener, want to look past that initial spectacle and understand the current status of this case almost a year later.
And looking at the materials you provided, understanding that current status actually requires dismantling the mechanics of the operation itself.
Right.
We have to look at how a local sheriff's department orchestrates a digital dragnet, right? How the resulting charges are just meticulously stacked to eliminate defense loopholes.
Yeah, that part is wild.
And we also need to look at how different federal and civil jurisdictions suddenly, collide at a county booking desk.
Okay, let's unpack this, starting with the sting itself. Because according to your notes, the Morgan County Sheriff's Office didn't just stumble upon these individuals during, routine traffic stops.
Oh, no, not at all.
Operation Fright Night was a targeted, proactive effort. They were explicitly hunting for individuals engaging in online child solicitation. But what immediately caught my eye in your research is that when the dust settled and they announced the arrests of these 4 specific men, every single one of them faced the exact same triad of severe official charges.
Yeah, identical charges.
Right. First-degree human trafficking, traveling to meet a child for an unlawful sex act, and electronic solicitation of a child. It's just uniform across the board for all 4 guys.
Well, that uniformity is definitely not a coincidence. I mean, it is the architectural blueprint of a modern digital sting operation. When a prosecutor and a law enforcement task force agree to bring this specific combination of 3 charges simultaneously, they are establishing an airtight chronological timeline of a crime.
A timeline. Okay.
Yeah. They are mapping out the escalation from a purely digital thought to a physical action, culminating in, the most severe felony possible.
I want to break down that progression because, to someone just reading the police blotter, it just sounds like a list of terrible things.
Right. It's just legal jargon to most people.
Exactly. But mechanically, how does this actually work? Let's start with the foundation, which is electronic solicitation of a child. This is the digital intent, right? Like the conversation happening on a smartphone or a laptop.
Precisely. So in the context of an operation like Fright Night, law enforcement sets up digital decoys. Undercover officers populate chat rooms or, social media platforms or dating applications, and they pose as minors. And the foundational charge of electronic solicitation requires the state to prove that the individual initiated or engaged in communications that explicitly crossed the line into soliciting illegal acts.
So they have to prove what was actually said.
Yeah, and the digital forensics here are absolutely critical. I mean, the prosecution doesn't just need to show that a conversation happened. They need to extract the metadata, the chat logs, the device identifiers.
To tie it to that specific person.
Exactly. To prove beyond a reasonable doubt that the suspect believed, based on the undercover officer's representations, that they were communicating with an actual minor.
But a conversation, even an illegal, horrific one, is still just, data packets bouncing off the cell tower. I imagine defense attorneys could have a massive field day with just that one charge alone.
Oh, absolutely.
Like, they could just argue it was purely a digital fantasy, right?
Mhm.
A horrific role play, sure. But that their client never actually intended to cause real-world harm. Like, they never planned to leave their couch.
And that was actually a massive loophole in the justice system for years as the internet first evolved. Law enforcement realized pretty quickly that they couldn't just arrest people for typing words.
Because you can't prove they were going to do it.
Right. Because intent without action is incredibly difficult to prosecute in front of a jury, you know?
Yeah.
And that historical friction is exactly why the second charge exists.
The traveling charge.
Yes. Traveling to meet a child for an unlawful sex act. This law was specifically crafted by legislatures to bridge that gap between digital fantasy and physical danger.
Ah, so this is where the digital net gets pulled tight. Like, you don't arrest them while they're just sitting at home typing. You give them a physical address,
Right.
a local motel in Decatur, or a
Right.
parking lot, or a designated meetup spot.
You give them a location and you wait.
Wow.
Yeah. To levy the traveling to meet charge, the state has to demonstrate physical movement in furtherance of that digital crime. So the suspect has to get off their couch, get into a vehicle, and physically navigate to those established coordinates.
And once they do that,
When they arrive at that physical location, they cross a massive legal and psychological threshold. I mean, they have objectively demonstrated that their digital intentions are now physical realities.
because they showed up.
Exactly. If a defense attorney tries to argue that the chat logs were just fantasy, well, the prosecutor simply points to the GPS data of the suspect's vehicle arriving at the sting location.
Right. It totally kills the argument.
It does. The physical action neutralizes the fantasy defense completely.
Okay, that makes perfect sense mechanically. But it's the third charge in this triad that I find, honestly, genuinely confusing.
The trafficking charge?
Yeah, first-degree human trafficking. Because when I hear human trafficking, my brain immediately goes to, international borders, organized crime syndicates, shipping containers, like massive transnational networks.
People's minds do go there.
So how does a guy driving across town to a motel in Morgan County get hit with first-degree human trafficking?
It's a very, very common misconception. The legal definition of human trafficking is actually much broader and often far more localized than, the cinematic version we see in movies.
Yeah.
In Alabama, and honestly in many other jurisdictions too, the charge of first-degree human trafficking can be applied when an individual attempts to arrange, facilitate, or purchase a commercial sex act, particularly involving someone they believe to be a minor.
So it's really about the economics of the crime.
Yes, the demand-side economics.
Uh,
By arriving at that location with the intent to engage in these acts, the individual is actively participating in the demand side of the trafficking market.
they are paying for it or exchanging something for it.
Right. They are commodifying a human being.
Yeah.
And law enforcement agencies increasingly stack this trafficking charge on top of the solicitation and traveling charges because it carries immense felony weight.
Like severe prison time.
Very severe. We're often talking about a Class A felony carrying decades in prison. It reflects the true severity of the intent to commodify a person, even if that person was, technically a law enforcement decoy.
Let me make sure I'm synthesizing this correctly because this is fascinating. You have the chat logs proving the digital intent for the solicitation charge.
Right.
Then you have the GPS data and the physical arrival proving the action for the traveling charge.
Exactly.
And then you have the commercial or exploitative nature of the meetup anchoring that massive first-degree human trafficking charge. It is like a three-step lock.
It really is.
If the suspect denies the trafficking aspect, well, you have the physical travel. If they deny the travel intent, you have the chat logs. It's literally designed to be inescapable.
It anticipates the standard defenses and structurally dismantles them right at the moment of arrest. I mean, it is basically a prosecutor's ideal framework for a digital sting.
Here's where it gets really interesting, though. We've established this uniform, inescapable net that all four of these men walked into. But when you look past the police press release and dig into the actual booking records from the Morgan County Jail, which, by the way, you provided in your research, the uniformity vanishes entirely.
It completely fractures.
Yes. The moment these men reach the booking desk, their legal realities fractured based on the baggage they brought with them.
So the sources outline the four specific individuals arrested. We have Logan Michael Hansard, he's 28, from Decatur. Terrance Carter, 33, also from Decatur. Barry Kanan Cook, 36, from Decatur. And Raul Aleman, 47, from Danville.
Okay, so four local men.
Right. Four local men, all facing the exact same triad of primary charges. But for Carter and Aleman, the booking log reveals these additional severe detainers that completely alter their trajectory in the system.
Let's start with Terrance Carter, because in addition to the 3 Fright Night charges, his booking shows an outstanding child support warrant. Now, usually when people hear, a child support issue, they think of a civil dispute.
Like a garnished paycheck or something.
Yeah, exactly. But this is listed as an active warrant for exactly $11,940.26. I mean, that is an incredibly precise, incredibly high number. How does a civil family court issue turn into a criminal hold at a county jail?
It really highlights the compounding nature of the justice system. A child support warrant of nearly $12,000 doesn't just materialize over a few missed payments.
No, that's a lot of money.
Exactly. It represents a documented, protracted history of entanglement with the family court system. We are talking about months, likely years, of unpaid obligations, accumulating arrears, interest, and crucially missed civil court dates.
Oh, so ignoring the judge.
Right. When an individual repeatedly ignores court orders to pay or appear, the civil judge will eventually issue a bench warrant for contempt of court. It crosses the line from a simple civil debt to a blatant violation of a judicial order.
So essentially, the system was already hunting for him before Operation Fright Night even existed.
The system has a very long memory. When Carter was brought into the Morgan County Jail and fingerprinted, his biometrics were run through state databases. And that outstanding family court warrant immediately flagged and attached itself to his criminal booking.
Wow.
The implication here is massive. I mean, even if a judge looked at the Fright Night charges the very next morning and dismissed them entirely, let's say due to some procedural error by the police, Terrance Carter is not walking out the door.
Because of the family court hold.
Exactly. The sheriff is legally obligated to hold him on that $12,000 warrant until he is transported to a family court judge to answer for the contempt.
It's a cascading failure for the defense. Like, you are suddenly fighting a massive felony criminal case while simultaneously being held hostage by a civil contempt warrant from years prior.
It's a nightmare for a defense attorney.
But as complicated as that is, the fourth individual, Raul Aleman, faces a detainer that operates on a completely different jurisdictional level. His booking indicates he is subject to an ICE detainer.
Right. And what's fascinating here is how a localized county sting immediately triggers the machinery of the federal government.
Yeah, how does that work?
Well, ICE, or Immigration and Customs Enforcement, is a federal agency under the Department of Homeland Security. When Aleman was booked, just like Carter, his fingerprints were scanned. But those prints don't just stay in Alabama.
They go national.
Right. They are instantly transmitted to the FBI's National Crime Information Center, or NCIC, and DHS databases. And if those systems flag the individual as someone who is in the country unlawfully or who has, violated their immigration status, ICE is automatically notified.
But I'm struggling to see how this actually plays out mechanically at the county jail. I mean, the Oregon County Sheriff isn't a federal immigration officer, right? They enforce state law.
Correct.
So if they pull this guy in on a local sting, is there literally an ICE agent sitting in the local precinct waiting for him? Or is this all happening, in the cloud?
It is an entirely automated bureaucratic communication. ICE doesn't dispatch an agent immediately. Instead, they issue what is formally known as Form I-247A.
Okay, and what is that?
This is the actual ICE detainer. It is a written request sent from the federal government to the local Morgan County Sheriff. It essentially states, we have probable cause to believe this individual is removable from the United States under federal immigration law. When your local legal processes are concluded and this person is ready to be released from your custody, do not let them walk out the door.
Wow.
Hold them for an additional 48 hours so our federal agents can arrive and take custody.
This raises an important question about jurisdictional friction, though. Because what happens if the state of Alabama desperately wants to prosecute Aleman?
Right, for the Fright Night charges.
Yeah. They want to put him in state prison for 20 years for first-degree human trafficking.
Yeah.
But the federal government wants to deport him. Who wins that tug of war?
Usually, the state gets the first bite at the apple, so to speak. The criminal charges take precedence, so the state of Alabama will prosecute him, and if convicted, he will serve his state prison sentence in an Alabama facility.
So where does the ICE detainer go?
The ICE detainer simply sits on his file, dormant, for years or even decades. The moment his state sentence concludes, whether that's in 2026 or 2046, the prison will not release him to the public.
They trigger the 48-hour hold.
Exactly. They will activate the detainer, hold him for 48 hours, and transfer him directly to federal IC custody for deportation proceedings.
But let's look at the immediate reality of October 2025.
Hmm.
What if Aleman's family showed up to the Morgan County Jail tomorrow with a briefcase full of cash?
Yeah.
Right, like ready to post bail for the Fright Night charges.
Okay.
If the local magistrate says, okay, the state bail is met, he's free to go, does the ICE detainer step in and block it?
The briefcase of cash becomes completely irrelevant to his freedom. If the state bail is posted, the state simply steps back, the 48-hour federal clock starts ticking, and he transitions from state criminal custody into federal civil immigration custody.
Oh, wow. So he still doesn't get out.
No. He would likely be moved to an ICE detention center while fighting the Fright Night charges from afar, or, facing immediate deportation proceedings. It creates a nightmare scenario for his defense attorney.
Because now they have to litigate a complex state felony while their client is locked in a federal immigration facility somewhere else.
Exactly.
So tracing these arrests, you really see four men walk into the same digital trap, but they hit the jail with entirely different realities. Two are facing the raw weight of state felonies. One is tangled in a $12,000 civil court web, and one is caught in a massive federal immigration net.
It perfectly illustrates how localized criminal behavior can trigger this massive cascade of civil and federal consequences.
But here's the massive twist in the documents you provided. We just spent all this time talking about bail and hypothetical briefcases of cash and ICE blocking release.
Right.
But according to the October 2025 records, none of the four men, not Hansard, not Cook, not Carter, not Aleman, had the option to simply pay bail and walk out.
The briefcase of cash wouldn't have worked for any of them.
No. Regardless of their detainers, they were all held without bond. And the reason for that is a very specific, very powerful legal mechanism in Alabama called Aniah's Law.
Yeah, Aniah's Law is crucial here. To understand why all four men were held without bond right out of the gate, we really have to look closely at the constitutional history of bail.
Okay, let's do that.
Historically, the Eighth Amendment of the U.S. Constitution, and, many state constitutions, including Alabama's, guaranteed the right to bail for almost all offenses.
Right, with a rare exception of, capital murder, I think.
Exactly. The exception of capital murder, almost everyone had a right to bail.
Yeah. Because the foundational assumption of American law is that you are presumed innocent until proven guilty. If you haven't had a trial, the government can't just lock you away indefinitely. The bail money is just collateral to ensure you show up to your court date.
That was the traditional framework, yes. The system was designed around flight risk, not community danger. And this meant that judges often had their hands legally tied. I mean, a judge could look at a suspect charged with a horrific, violent crime, review their history, and genuinely believe this person was an immediate severe threat to the public. But if the charge wasn't capital murder, the Alabama Constitution dictated that the judge had to set a financial bail amount.
Which essentially meant that if a highly dangerous predator had a thick enough wallet, they could just buy their way back onto the streets while waiting for trial. The system was assessing their wealth, not their risk.
And that friction is exactly what led to Aniah's Law. The documents you provided highlight this specifically. Aniah's Law is not just a standard statute. It is a fundamental amendment to the Alabama state constitution, which was overwhelmingly passed by voters. It was designed to completely restructure that historical framework we just talked about.
So what did it change?
It expanded the list of severe offenses, including human trafficking and violent crimes, for which a judge now has the constitutional authority to deny bail entirely.
It's a shift toward preventative detention. It's the state basically saying, we're no longer just worried about whether you will flee to Mexico. We are worried about what you will do to the community if we let you out.
Precisely.
And looking at Operation Fright Night, prosecutors immediately moved to apply Aniah's Law to all four suspects. The argument is clear. Human trafficking and electronic solicitation of a child are highly predatory, high-risk behaviors. The state is asserting that these individuals pose an inherent, unacceptable danger to the public, specifically children, if released.
But Aniah's Law isn't an automatic dictatorial lockdown. The Constitution still requires due process. When prosecutors invoke Aniah's Law, it triggers a very specific high-stakes legal mechanism, which is the Aniah's Law hearing. And the documents note that all four men were scheduled for these hearings shortly after their arrest.
What actually happens in that room? Because they haven't had a trial yet. A jury hasn't convicted them of the Fright Night charges. How does a judge decide to take away their freedom based on just an accusation.
So the hearing functions almost like a mini trial, but
Yeah.
it's entirely focused on risk assessment. The burden of proof rests heavily on the prosecution.
They can't just say, trust us.
No, the state cannot simply slide the police report across the desk and ask for a lockup. The prosecutor must present tangible evidence to the judge right then and there.
Like what?
Well, they might introduce the explicit chat logs or call the arresting officer to testify about the suspect arriving at the meetup location. They have to prove, by clear and convincing evidence, that the suspect committed the offense and that no condition of release, no ankle monitor, no house arrest, no massive financial bond could reasonably ensure the physical safety of the community.
Wow. I think of Aniah's law like a judicial pause button. Normally, you are arrested, you get booked, and you are immediately placed on this bureaucratic conveyor belt that calculates the bail amount and spits you back out onto the street.
Yeah, that's a good way to put it.
But Aniah's law slams the emergency stop on that conveyor belt. It forces everyone, the judge, the prosecutor, the defense, to just stop and prioritize community safety over the accused's ability to pay. Only if the judge is overwhelmingly convinced by the evidence will they press the button to lock you in until the trial.
It fundamentally alters the calculus of pretrial freedom in Alabama,
Right.
making it about public safety rather than financial means.
But this brings us to the crux of your deep dive, the very reason you, the listener, brought these documents to us today.
Right.
You've traced these men from the digital net, through the severe charges, past the civil and federal detainers, right up to the doors of the Aniah's law hearings in October 2025. But when you try to look at what happened next, you hit a brick wall.
A total dead end.
Today is July 18th, 2026. Almost 9 months have passed. According to your research, there are 0 public updates. No court dispositions, no news articles about the hearings, nothing. Complete silence.
And this is where the illusion of the television procedural shatters completely. It is incredibly jarring for the public to witness a massive, sensational operation like Fright Night and then experience 9 months of a total information blackout.
So what does this all mean? If I'm a citizen in Morgan County, my mind immediately goes to conspiracy. Like, did the system fail? Did these guys get released on a technicality in some backroom deal? Why is nobody talking about this?
The silence feels like an anomaly, but it is actually the standard operating procedure of the justice system.
Yeah.
Serious criminal cases, especially those involving complex digital forensics and first-degree felony charges, move at a glacial pace.
Glacial.
Yes, a 9-month gap with no public resolution is entirely typical.
Take us behind the curtain then. If the public isn't hearing anything, what is actually happening during those 9 months? What is the machinery doing?
So after the initial Aniah's law hearing, whether they were held or released, the case enters the grueling phase of discovery. The defense attorneys for Hansard, Carter, Cook, and Aleman have a constitutional right to request, review, and challenge every single piece of evidence the state holds.
And in a digital sting, this is a monumental task.
Oh, massive.
Right, because it's not just a physical weapon they're analyzing.
Yeah.
It's digital data. Terabytes of it, probably.
Exactly. The defense needs to review every single line of the chat logs. They need to see the body camera footage from the arrests. But the biggest bottleneck is digital forensics.
The devices.
Right. When these men were arrested, law enforcement likely seized their smartphones, their laptops, hard drives, everything. Those devices are sent to state crime labs to be imaged and analyzed for further evidence of exploitation.
And I'm guessing that's not a quick process.
Not at all. State cyber labs are notoriously underfunded and massively backlogged. It can take 6 to 8 months just to get a forensic report back on a single iPhone.
Wow. And while they're waiting on that data, the defense isn't just sitting idle, are they? They're likely filing pretrial motions to dismantle the state's case piece by piece.
The defense will systematically attack the foundation of the operation. They might file motions to suppress evidence, arguing that, the initial digital search was unconstitutional.
Oh, like claiming the police went too far in the chat rooms.
Yes. Or they will almost certainly argue entrapment, asserting that the undercover officers coerced or aggressively persuaded their clients into traveling to the location, and that the suspect wouldn't have committed the crime without police interference.
Right.
And every single one of these motions requires the judge to schedule a hearing, hear arguments from both sides, review case law, and issue a formal ruling.
It is a grinding procedural slog. It happens in these empty courtrooms on Tuesday mornings, far away from the flashing lights of the initial arrest. And we have to reiterate a legal absolute here. During this entire 9-month slog, all 4 of these men are presumed innocent under the law.
That is vital to remember.
An arrest, even in a highly publicized sting operation named Fright Night, does not equate to a conviction. The state still bears the massive burden of proving its case beyond a reasonable doubt to a jury or, forcing the evidence to a point where the defense has no choice but to negotiate a guilty plea.
This raises an important question about the life cycle of information and how we actually consume news. There is a massive inherent friction between how law enforcement utilizes the media and how the court system actually functions.
Yeah, look at how this whole saga started. The Morgan County Sheriff's Office put out a high-profile press release. They deliberately gave the sting a catchy seasonal name, Operation Fright Night.
Capitalizing on the October date.
Exactly, to maximize media traction. They released the mugshots. This is designed to generate immediate, intense community engagement. The local news runs it at the top of the broadcast. It is sensational, it's terrifying, and it signals to the public that the police are actively cleaning up the streets.
And law enforcement relies on that initial media blast to justify their budgets, demonstrate their effectiveness, and deter future crimes. But once that press conference ends, the court system takes over.
And the court system does not care about the daily news cycle.
Not at all. It operates entirely on procedural law and constitutional rights.
And the media, by its very nature, is a machine that constantly demands new fuel. I mean, a local news station does not have the budget or the personnel to assign a reporter to sit in a Morgan County courtroom for 9 months, waiting to see if a judge rules on a motion to suppress digital evidence in a local sting.
No, they move on to the next daily emergency.
Which leads directly to the information blackout you're experiencing. You are looking for the end of a story that the media abandoned at Chapter 1.
Right.
And the documents you provided highlight a perfect, almost poetic example of this phenomenon. You included a link in your research to a local news article from a station called Rocket City Now. This link was supposed to be your source for the details of the original October arrests. But what happens when you click it today, in July 2026?
It's a dead end.
It's totally dead. You literally wrote down the error message in your notes. Access denied. You don't have permission to access on this server, followed by a string of useless reference code. The article is gone. The URL is broken.
This is known as link rot. It is a really pervasive issue in digital research.
The grot.
Yeah. As local news stations update their servers, change their content management systems, or simply purge old stories to save on data hosting costs, the initial sensational reports just vanish into the digital ether. The initial headline is incredibly loud, but its digital lifespan is remarkably short.
So if the media has moved on, and the news links are literally rotting away, how do you actually track the truth? How do you find out if Hansard, Carter, Cook, and Aleman are sitting in state prison, deported, or walking free? Your research points to a very specific actionable step. You have to bypass the media entirely and go directly to the source. You have to use Alicourt.
Yes. Alicourt is the Alabama Unified Judicial System's court records portal. It is the primary official database for ongoing research into legal proceedings in the state.
To be clear, this is not a news website.
No.
There are no catchy headlines or sensational summaries. It is the raw, unfiltered data of the justice system.
It is the bedrock of tracking justice. By logging into Alicourt and searching the specific case numbers or the names of the individuals, you completely bypass the information blackout. You can look at the actual docket.
The real files.
Yes. You can see the result of the Aniah's law hearing, like were they denied bail or released. You can see every motion filed by the defense regarding entrapment or evidence suppression. You can see if a trial date has finally been set, or if a plea deal was negotiated in private and accepted by the judge.
Or, as is highly likely given the typical duration of these cases, you might look at Alicourt today and see that the cases simply remain pending.
That's very common.
A long list of procedural delays, continuances, and forensic bottlenecks. Tracking this requires effort. It requires looking past the broken links and the flashy operation names and digging through dense legal portals.
Yeah.
But that is the only way to anchor yourself to the reality of the situation.
Let's summarize the journey we've taken through your research. You started with a handful of names, some rotting hyperlinks, and a flashy operation title from October 2025. Now you have a comprehensive mechanical understanding of the systems at play.
We've traced the anatomy of the Fright Night charges, understanding how law enforcement layers electronic solicitation, traveling, and first-degree human trafficking to trap digital intent and physical action in an inescapable legal net.
Right.
We've contrasted the suspects, realizing that while they all face the same primary charges, their experiences at the booking desk were radically different. Terrance Carter was instantly snared by a deeply precise $11,940.26 civil warrant from family court, illustrating the compounding memory of the justice system.
And Raul Aleman was hit with a federal ICE detainer, sparking a jurisdictional tug-of-war between state prosecutors and federal immigration agents.
You also understand the profound impact of preventative detention. You know that Aniah's law isn't just an arbitrary hold, but a fundamental constitutional shift in Alabama designed to prioritize community safety over financial wealth. It acts as a judicial pause button for high-risk charges.
And finally, you understand the timeline. You know why there is a 9-month silence. You recognize the friction between public relations stings and slow-moving courts, and you know how to use tools like Alicourt to find the raw truth.
Honestly, it validates exactly why we tailor these deep dives for you, the learner. Most people consume the news like fast food. They read a headline about Operation Fright Night, they look at the mugshots, they experience a brief flash of outrage or relief, and they never think about it again.
But you wanted to look under the hood.
Yeah. You wanted to understand the actual mechanics of local law enforcement, the jurisdictional friction with federal holds, the constitutional application of Aniah's law, and the reality of the judicial timeline. That relentless curiosity is how we actually build an informed public.
It is the crucial difference between merely consuming news and genuinely understanding systems. You now understand the massive, complex system surrounding these specific documents.
And as we wrap up, I want to leave you with a final thought to mull over, a thought that builds on everything we've discussed today, particularly that broken Rocket City now link. We live in an era defined by our expectation of instant, real-time transparency.
We really do.
We track our $20 packages on a live map.
Yeah.
We watch our food deliveries approach our house turn by turn. We get push notifications absolute second a news story breaks anywhere in the world. We are deeply conditioned for instant, visible resolution.
Right.
But when it comes to the most serious mechanism in our entire society, the justice system, the system with the awesome power to strip away someone's freedom, tear them away from their family, deport them, or brand them a felon for life, the process happens almost entirely out of the public eye.
Completely hidden.
It stretches over months and years, locked away in quiet courtrooms and behind dense, paywalled portals like Alicourt, while the public-facing news links just quietly rot away and return access denied errors.
Wow.
It makes you wonder, does the slow, silent, invisible nature of the court system actually serve justice better, insulating the process from the daily outrage and mob mentality of the internet? Or does it just make it dangerously easy for the public to completely forget what happened after the initial headline fades, leaving the accused, the victims, and the community trapped in a permanent state of unresolved, unseen limbo?
That's a tough question.
It's something to think about the next time you see a flashy law enforcement press conference on the evening news. Thank you so much for bringing this incredible stack of research to the table today. Keep digging, keep asking those hard questions about how the world actually works, and we will catch you on the next deep dive.